Companies Act Section 58, Refusal of Registration of Securities and Appeal against Refusal under the Companies Act. 1. Introduction. The transfer and transmission of securities are fundamental elements of corporate governance, ensuring smooth transitions of ownership and financial interests in companies. However, there are circumstances where companies may refuse to register a transfer or transmission. This provision, under the Companies Act, addresses both the company's obligations when it declines to register a transfer or transmission and the recourse available to aggrieved parties through appeals to the tribunal. The Act lays out the procedures, timelines, and consequences for both companies and shareholders to ensure transparency, accountability, and fairness in securities transactions. 2. Refusal of registration by companies. A company, particularly a private company limited by shares, has the discretion to refuse to register the transfer of securities or the transmission of ownership by law, such as inheritance or legal succession. However, this refusal must follow certain prescribed procedures to prevent arbitrary decisions and to ensure the affected parties are properly informed. Obligation to send notice of refusal. If a private company refuses to register a transfer or transmission, it is required to notify the affected parties within 30 days of receiving the relevant documents. The notice must provide clear reasons for the refusal. This notice should be sent to 1. The transferor and transferee, in case of transfer. 2. The person notifying the transmission, in case of transmission by law. Failure to send the notice of refusal within the specified timeline may result in legal consequences, as detailed in later sections. 3. Transferability of securities in public companies. While private companies have greater control over the registration of securities, public companies must ensure that the securities or interests of their members are freely transferable. Exceptions and contracts governing transfer of securities. Free transferability is the norm in public companies, ensuring a liquid and open market for shareholders. However, contracts or arrangements between shareholders relating to the transfer of securities are still enforceable under law. This allows for shareholder agreements and preemptive rights to govern the transfer of shares, even within the framework of free transferability. 4. Appeal to the tribunal against refusal of registration. If a company refuses to register a transfer or transmission of securities, the aggrieved transferee or person notifying the transmission has the right to appeal the decision to the tribunal. The Act sets specific timelines for filing such appeals, ensuring that the process is not unduly delayed. Timelines for appeal. 1. If notice of refusal is received. The appeal must be filed within 30 days from the date of receipt of the notice. 2. If no notice is received. The appeal must be filed within 60 days from the date on which the instrument of transfer or intimation of transmission was delivered to the company. Public company scenario. If a public company refuses to register a transfer or transmission without sufficient cause, the aggrieved party can file an appeal within 60 days from the date of refusal. 90 days from the date of delivery of the instrument of transfer or transmission, if no response is received from the company. 5. Powers of the tribunal. The tribunal plays a critical role in ensuring fairness when a company refuses to register the transfer or transmission of securities. After hearing the appeal, the tribunal may either dismiss the appeal or issue an order to provide relief to the aggrieved party. Possible orders of the tribunal. 1. Direction to register transfer or transmission. The tribunal can order the company to register the transfer or transmission within 10 days of receiving the order. 2. Rectification of the register and compensation. The tribunal can also direct the rectification of the company's register if it finds the refusal unjustified. Additionally, it may order the company to pay damages to any aggrieved party for the losses incurred due to the wrongful refusal. 6. Penalty for non-compliance with tribunal's order. If the company or any individual fails to comply with the tribunal's order, they will face serious legal consequences. This provision ensures that companies adhere to the tribunal's directives and do not frustrate the appeal process. Punishment for contravention. Imprisonment. The person in default shall face imprisonment for a minimum term of 1 year, which may extend to 3 years. Fine. A minimum fine of 1 lakh rupees shall be imposed, which can extend up to 5 lakhs rupees. These penalties underscore the importance of complying with tribunal orders and maintaining transparency in the handling of securities transactions. 7. Key takeaways. Private companies have the discretion to refuse registration of transfers or transmissions, but such refusals must be communicated within 30 days with valid reasons. Public companies are required to ensure free transferability of securities, though shareholder agreements may still govern certain aspects of transfers. Aggrieved parties can appeal to the tribunal against unjustified refusals, and the tribunal can issue orders to register the transfer or rectify the register. Strict penalties are imposed for non-compliance with tribunal orders, including imprisonment and fines, ensuring that companies act lawfully and in good faith.